Hi, this is Attorney Mike Grevlin coming to you from Chicago as usual. And today we got a little bit of a serious one. I did one previously on a SovCit. I sanitized it slightly just because the allegations are really disturbing. The criminality alleged is bad. This is a follow-up to that. That I was doing primarily because he was doing the SovCit routine, but in substance, it's pretty disgusting. Here he is for his follow-up appearance, and while the allegations are disturbing, the hearing is ultimately satisfying. At least I think it is.
Go on.
Yeah.
Yes, okay. What is the bond for your client? Is it $250?
Yes, that's correct.
Argument.
Judge, my client's 38 years of age. He's on Social Security disability, Judge. I don't see any criminal history for Mr. Pollard, Your Honor. He lives in the city, does have a child. Your Honor, this alleged incident occurred back in 2000.
Okay, at least we've got an attorney, and he's using his proper name instead of this beneficiary nonsense that he tried in the first hearing. I'll put a link to that in the description below.
2020. So some 4 years ago, obviously, it's a serious case, obviously, but it's 4 years old, Judge. He has no priors. I'm asking respectfully for a reduction in bond. The bond is $250,000 cash. Judge, I know the court will impose a GPS tether. I already know that, Judge. My client, in fact, Judge, he has a tether already on. He has a tether already on. Let me be clear about that. There's a misdemeanor, and I apologize, Judge, if I said something wrong initially. There's a misdemeanor that he has the tether for, so it's a misdemeanor.
Okay.
Your Honor. And he does a lawn care service, so he does have some work that he does. But the court doesn't have to worry about tether. I'm just asking for a reduction in bond to either a high part, some type of 10% bond. I think $250,000, Judge, is excessive. Thank you.
Okay. Mr. Prosecutor.
Judge, the defendant on the screen today in the top left, he's being charged with sexually assaulting a 7-year-old. The assault allegedly happened at his house in his bed. Your Honor, this is an individual who allegedly is self-proclaimed part of the tribe of Judah. Mm-hmm. This is also an individual that I actually had the opportunity to watch the arraignment regarding the defendant in this case, gave the magistrate such a hard time that multiple magistrates actually ended up having to handle the matter because he wouldn't give up his name or his identity. Mm-hmm. Now, being charged with this and now knowing what his past is like, I may refrain from giving a magistrate or a judge my name as well. Because, Judge, the situation that Mr. Reagan is talking about that the defendant's involved in right now, it has to do with selling and furnishing alcohol to minors, to a 12-year-old and 14-year-old. It actually originally began as a criminal sexual conduct first degree where the defendant allegedly was having sex with the 12-year-old. But, Your Honor, based on apparently the idea that somebody didn't appear at a hearing, it was reduced to the selling and furnishing of the alcohol. So he has an ongoing matter right now, Judge. He's on bond. We have this particular matter, allegedly, where this individual ended up touching a 7-year-old's vagina. We have corroboration to that, Judge. And, Your Honor, with all due respect, the way that the people see this defendant based on previously being charged, now being charged with another CSE first degree, we find him to be a predator. Not only that, Judge, we find him to be mentally unstable. He's currently on a case regarding minors, 12 and 14 years old, and just plain and simple, Judge, we find him to be a danger to the community. Therefore, Judge, we do feel as though a high cash bond is appropriate. We do feel as though the magistrate got it right here in terms of the $250,000 cash, not just to this particular complainant, but kids, all kids. This is one of those individuals where we feel as though he poses a danger to everyone.
Mr. Ray, final words, if any.
I like that. No.
I wasn't privy to watching the arraignment, Judge, but obviously this court is very knowledgeable, and I'm going to, obviously leave it to this court. I wasn't privy to watching the
I was, and again, I'll put a link to it in the description below. It was obnoxious.
arraignment, though, Judge, so I can't really speak on that.
See, where we I haven't heard their arguments of counsel, where this gets a little dicey for concerning bond is that we have a situation where the defendant allegedly, I guess an 18-year-old comes in town to visit with him for her birthday. She turned 18, so she comes to see the 37-year-old who she's been in a long-term relationship with for the last 3 years. So I guess he would have been 34 starting the relationship with the 15-year-old. Allegedly, she talks to a friend and they come over and the 7-year-old is over. The girl comes and finds the two of them in the bed, and then the mother contacts a person asking who is this Kevin guy, because her daughter says he touched her vagina. So, and then we have another case of furnishing alcohol to 12-year-olds, and whether there's sex there or not sex there, we have a pattern that's a little bit concerning. It's a lot of minors, a lot of alcohol, a lot of sex allegations, a lot of molestation allegations, a lot of flying people in who are kids and teenagers, and so we're real concerned about this. So the $250,000 bond is an unaffordable bond, and so the court does find that this defendant is a danger to all kids. He's just a danger. The court is going to disagree with the magistrate on this, and I know the magistrate or magistrates had some issues with this defendant, and they used the information that they had at this time to come up with the $250,000 bond. But the court does find that Mr. Pollard poses a great danger to the community, and a $250,000 bond is unaffordable, but it's not enough. It's not enough. So what we're going to do is we're going to add something to it to make sure he's incapacitated. But if he posts the bond, then that means we know that he'll appear for court. So the bond is going to be increased to $1 million, and that'll be $1 million cash. If he makes the $1 million, then he'll be placed under house arrest with GPS tether. And Mr. Pollard is not to have any interactions with anyone under the age of 18, whether they're family, whether he knows them. He's not to be around anyone under the age of 18. If he is, that will violate this bond. Thank you.
So, Judge, the bond was $250,000 cash.
Yeah, and now it's $1 million cash. Now it's $1 million cash. Okay. It's $1 million now. It's $1 million now. Okay, because he's on Social Security disability now. Can't afford it. I understand, but the court finds that Mr. Pollard, it may be some serial actions going on right here, and I don't really know if he's like a serial rapist. I don't know if there are other children that he just lays in the bed with allegedly and touches, or there's other 12-year-olds, or if he's flying other 18-year-olds out to celebrate their birthday. I'm not sure. So what we have to do is we're going to err on the side of caution and make sure that Mr. Pollard is not able, at least right now, to be able to engage or even be charged with engaging in these type of activities.
Yeah, no, Judge, I get it. I know it's rough when the allegations are from January of 2020, but the prosecutor doesn't charge until January 24. I mean,
Yeah, it's when it looks like it wasn't until October 14th of 2023 when the mother called asking who is this Kevin guy. So that we just kind of got that information, and I'm not sure when the 12-year-old. I'm not sure when all the 12-year-old and the alcohol when that happened. So it's a lot, Mr. Reagan, and so the timeline may get a little bit jumbled. But it's a lot of kids, teenagers, alcohol, sex, molestation. It kind it's kind of blending. And so, you know, we're here where we are.
Yes,
All
sir.
right, thank you. Mr. Pollard, you can leave.
Thank you, Judge.
All right. Ladies and gentlemen from Cass Technical High School, you're gonna go with LaDon, and you're gonna move up. Yeah. I had to go Madison on it. All right. I will see you guys in approximately an hour, and we'll keep it going.
Well, there you have it. I think the right thing happened there. That was excellent. The defense attorney did a nice job advocating for his client. His best argument was the charge is old, but then you realize, well, the information trickled back to the prosecutor slowly, and that makes sense given the ages involved. It really does. So, you know, this is, I tend to have fun hearings on I mean, they're all serious in their way, but they can be more fun. This one was more serious, but it's also a follow-up to one I did. And people want to know what happened. So that's what happened, which I think is the right thing. I think the magistrates did a good job. They put him at $250. The judge. So apparently you get a hearing if it's set as an unaffordable bond. $250,000 was completely unaffordable for a guy who's on Social Security disability. Another thing, of course, he's already a ward of the state. But it's already unaffordable. He's not going anywhere with the $250,000 bond. Moving it up to $1 million does not change much. He couldn't make the last bond. He certainly can't make this one. But it does send the right message. I think the judge did a good job. I think his defense attorney did a good job. Also, again, you have to see the first hearing. But this, you know, we couldn't even get past. Past the name thing, of course, because he's pulling all the sovereign citizen stuff, which is annoying enough with the traffic offense. But when these are the charges, it's particularly hard to stomach. Here at Law Talk, we like to have fun with silly stuff that happens in court, and every once in a while, and completely by accident, I assure you, you might learn something. Thanks for watching.